afternoon and welcome to the third in our series of remote family law seminars. I'm Sian Smith and I'm here as they turn their videos on with Gemma Taylor QC and Sharon Bachu, and we're all family law barristers at 42 Bedford Row. And we're joined today by Gemma Polidore and Patricia Barry-Ralph, who will all be discussing parental alienation, and in particular the interface with public law proceedings. After the talk, which will be about 30 minutes, we'll have time for some questions. So if you do have any questions for our panellists, you'll see down the bottom of your screen, and I'm sure lots of you have used it before, there's a Q&A function, and if you click on that, you can type in your questions, and Gemma and I will put some, if not all of your questions to the panel at the end of the talk. As a reminder, the webinar is being recorded and it will be available via our Chambers YouTube channel after today. You are all on mute, so we can't hear anything you say, but obviously you can contact us on the Q&A or on the chat function. So now I'm going to hand over to Sharon, who's going to introduce you to each of our guests and to this evening's topic. Thank you.
Hello everyone, welcome to the seminar today. I'm delighted to introduce Gemma Polidore, who is a family law solicitor at Venters with offices in London and Reigate. Gemma deals with all aspects of family law, but with a particular interest in matters relating to children, whether in private or public law proceedings, and she's accredited by the Law Society for work relating to child abduction, wardship and private children matters. And I should say that she has a particular interest because it's something we've talked quite a lot about in terms of parental alienation. We also are very lucky to have Patricia Barry-Ralph here, who is the co-founder of Co-Parenting Matters. She's a child and therapy consultant, a specialist systemic family psychotherapist, a play therapist, a family mediator, an independent social worker, and an expert witness. Is also particularly interested in parental alienation. Now that's a phrase or a label that actually us lawyers and parents often brand around, but it's much more complex, and the discussions today will focus on some of the complexities and also some of the subtleties, with help from Trish in really looking at the nub of the issue, the effect on the children. We have the very recent authority of Ries and the judgment of Lord Justice Jackson. Paragraphs 7 to 13 make very important reading when considering parental alienation within the child protection arena, and I would urge you to take a look at those along with this seminar. So in turning to our pre-recorded discussions, I started off by asking Gemma about some of her experiences with clients, particularly parents, in parental alienation cases, and what we, the advocates, should be looking out for from the very beginning.
Okay, so what I have done is made a list of some of the things that come up quite regularly if it is a case where it could be parental alienation. So one of the things is if a child is not spending any time with the non-resident parent for no reason, or they can't explain the reason as to why they don't want to spend time with that parent, or the reason that they're giving doesn't appear strong enough after you've kind of asked a few questions to warrant not having contact. The other thing is if a child is not speaking to anyone in the non-resident parent's family, especially if they were speaking to them before this became an issue, and again, if they're also speaking to the resident parent's family. If the child is speaking negatively about the non-resident parent and their family, and they'll say it to anyone who will listen and have no regard for the non-resident parent's feelings. This is especially if the child is relaying events that they wouldn't necessarily have knowledge of. For example, they weren't born, or they were so young that they were 1 year old, they wouldn't remember if mum and dad had an argument about the dishes, for example. If a resident parent is making unilateral parental responsibility decisions, especially if they share parental responsibility, that can be an issue. Another issue is if the resident parent is making very strict demands about how contact is supposed to look. So, for example, they're saying that contact has to be supervised or it has to be in a contact centre. And this is especially if contact, if there's no reason why, no safety reason why the non-resident parent shouldn't be having contact with that child. A couple other points is if the resident parent places the decision on whether or not contact should be taking place on the child, that it's a child should not be making those kind of decisions, and that burden shouldn't be placed on them. And this seems to happen a lot with older children. So as soon as they get a bit older, the resident parent will say they don't want to have contact, they're old enough to say it. You wouldn't allow your child to turn around and say they don't want to go to school or they don't want to go to the grandma's house. So you shouldn't really be encouraging your child to say, I don't want to see a non-resident parent. And one of the other points is if the resident parent has made repeated complaints to the school, social services, the GP, police, that's something also to be worried about, because you have to actually consider what these allegations are that they're making against a non-resident parent and the effect that making these allegations will have on the child. For example, the child may have to go through a medical exam or end up meeting a lot of different professionals, which is obviously not in their interest. Just one other thing I should point out is if a child just because a child may be doing well in another area of their life, for example, education, it doesn't mean that everything is okay. And
so I just want to come back to the last thing, because of course many of your lists will apply immediately to the private law cases that we all deal with. But actually that's not often the case, is it? And it's to ask you about your experience in terms of public law cases and actually sort of looking outside of the box when looking at that list. I appreciate it's not an exhaustive list of factors, but it's not just your simple private law case, is it?
No, not at all. These things happen in public law cases as well, and it may start off as these things, and then it gets bigger and bigger, and the allegations escalate to when you have allegations of sexual abuse or physical abuse. So it's something that everyone should be made aware of and should be looking at. If you are a local authority who's been contacted by a parent who's saying, my child doesn't want to see me, then it's something that that the local authority should be investigating, because it's not normal for a child to just say they don't want to see another parent. And in paying attention to these things, the local authority needs to not just think it's a private law issue, that it's just between two parents and it will sort itself out in court, or think it's enough to just be on a SIN plan, which is a child in need plan, which is obviously the lowest level of local authority involvement. Because unfortunately, being on a SIN plan doesn't give enough local authority involvement for you to keep a watchful eye on what's actually happening and provide necessary intervention.
And so once you've identified one or many of those points on your list, what are you then looking at doing? What's your next point of call?
If the matter ends up going to court, the main thing is trying to get a fact-finding hearing as soon as possible. There is case law that says that should be the case, but it's so important that a fact-finding hearing is happening, because if the non-resident parent is saying my child is being alienated, or you have a resident parent who is saying my child is being abused in some way by the other parent, either way, a child is suffering or at risk of suffering harm, no matter which one of those allegations ends up being true. And so it is something that needs to be dealt with quite quickly. Also, it's very difficult for anyone to work with this family, whether it be the local authority or the guardian or any professionals like Trish, if a fact-finding hearing hasn't taken place so that everyone's working on the same level. Everyone needs to have the same narrative. And if they don't have that, no work can be done to progress.
And that's the perfect point to bring you into these discussions, because of course you have a very different role within our discussions today. You come at it from the point of view of the children. Can I ask you, what do you see as the important considerations that us advocates, both at the front line in terms of Gemma being a solicitor, and when it gets to court, counsel, that we need to be looking out for?
I completely support what Sherma has just said about the fact-finding hearings. I think they are critically important. If I'm working with parents to try and support them to reduce the levels of conflict between them and help them to understand the damage onto children of not having a meaningful relationship with each parent, and the narrative each parent has is different, and it still hasn't been adjudicated upon, and one parent is saying, well, it's about you doing this and that's not really how it happened, it's not really my job to get involved and dragged into that, or to be in, you know, even sometimes doing expert witness assessments and giving evidence in court. Sometimes barristers will ask me, you know, well, you haven't said, you know, about what the parent is saying about domestic abuse. Well, you know, I'm not the judge. It's not for me to rule on facts. The facts haven't been found yet. But if a parent is recording, telling me during the interview, I will record what they tell me, and it's up to the judge to do that. And I think if that's done earlier, I totally agree that the narrative then between all the professionals and the parents, and the reason that they're coming to try and improve and reduce the level of conflict between them in the best interest of the child, is served, and you don't waste a lot of time. So I think that's really important, because time is the enemy in these cases. And the longer a child doesn't see a non-resident parent, the harder it is to restore that relationship. It takes time. And even in public law proceedings, which you'll be aware of, where children are removed as a result of abuse, sometimes, or neglect, they still crave a relationship with their parent. Whereas in parental alienation cases, it's not normal that suddenly they have no relationship. They haven't been abused, they haven't been neglected, and suddenly they're saying they don't want to see that parent. I think that if it's even longer than 3 months, it's too long. And some of the cases that I get are children who've already been alienated as children, and it takes an awful long time to rebuild the relationship with the parent who they've been alienated from.
Just to be clear, Trish, when you say 3 months, do you mean 3 months of no relationship?
Well, I mean 3 months. You know, any longer than 3 months, other research evidence in other countries is saying, if it's over 3 months, then you're already in difficulty. The child is in difficulty, and the parent who's not seeing the child is in difficulty. So that's why I often refer to this as a mental health emergency. So if I am instructed as an expert witness, and I'm told, well, it could be parental alienation, we're not sure. My job is to go in with an open mind. My job is to ask the question, why is this child resisting or refusing having a relationship or wanting contact with a parent who they previously had a good relationship with? Because that's not a normal thing to be doing, as Sherma, you've just said. And over time, the damages that happen to children is they feel guilty. They feel like they're part of their parents' conflict. They doubt their own goodness when they are saying to the other parent, I don't want to have anything to do with you. I don't want to see you. In their quieter moments, they feel they can't be good in themselves because they're rejecting a half of who they are, because they're a part of their mum and they're part of their dad. You've frozen on the screen. Sorry.
I'm going to pause you. I'm going to pause you for a second.
Okay. If the child isn't having contact, then it's very, very difficult, because the longer it goes on, the more urgent the need is to establish why that is the case. In some cases, it is complicated, and I agree with Sherma here. Sometimes a child might have been in a difficult relationship with a parent. They might have had difficulties that they haven't been able to resolve. Might be adolescent rebellion, and then the child decides they don't want to see the other parent, but the other parent hasn't been sympathetic to that. And the work needs to be done to clarify from the child's perspective what actually the presenting issues are for them. So I don't always jump to the conclusion it's parental alienation. It can be overlaid with lots of other complexities, lots of other history, lots of other people in the context of the family system who are also a party to that, and, you know, strengthen the splits and side with one side of the family or the other side of the family, which isn't good for the child. The children, in a way, learn to keep both parents happy for a long time where there's high conflict. And I agree again with Sherma that it's the precursor is the start of it is high conflict, in my experience. And the children can hold a loyalty to each parent for a considerable period of time, and then they just can't do it anymore. Because it's, after all, it's not their war, it's their parents' war. They can't resolve it. So some children will say, well, I don't want to really say anything about what I want because I'll upset one parent or the other, and one parent might feel rejected, so I don't tell them how I feel at all. And over time, that can develop into somatic complaints, headaches, stomach aches, a reluctance to give voice to their feelings. So it becomes somatized, because then they don't have to think about the feelings and they don't have to talk about the feelings. I think as it goes along, particularly in older children, you will see depression. And again, I want to pick up on Sherma's point about children who are getting A stars in school, who don't present to the teachers or the head teacher or the DSL, the deputy head teacher, as having any problems. And I've gone into schools and I've spoken to school staff in grammar schools and private schools and comprehensive sector about this. And when I've explained the impact on the child that they have known far longer than me, they go, well, actually, we can see that, but actually we couldn't see it. So the child isn't afforded protection by the professionals they're coming across because they can't identify it. And sometimes the schools will become embroiled in the family narrative of one of the parents. And then that validates the child's perspective of the non-resident parent who the child might not have seen. And I think that's difficult. I think CAMS is another issue. I think if children are sent for an assessment to child and adolescent mental health services, and they are anxious, for example, if the child and adolescent mental health services assess that case as a case needing treatment for anxiety outside of the whole of the family system, they're not really treating the root cause of why that child is anxious in the first place. So there are ways in which opportunities to help children are missed, not because people are deliberately setting about to do that, but because they don't have the knowledge and the experience to understand actually the whole family system as a unit. I think into adolescence, sorry. She's frozen again. Yeah. Into adolescence, the issues become quite different, because it's likely that by adolescence there has been probably problems in the parental relationship for a while. And developmentally, an adolescent's task is to separate from parents, is to look to the future for themselves, is to develop peer groups, is to kind of feel they can create an identity different from their parents, a philosophy and ideas separate from their parents. And where there is evidence of long-term influence of one parent against the other parent, and the child, where there is evidence that the child is resisting contact with a parent and they're into adolescence, it becomes more complicated. It becomes more complicated because they have more choice and they can make more choices. And, you know, in your 16 to 18-year-old age group, where some of the conflict issues have not been resolved and children have been exposed to that for very long periods of time, they will develop depression, anxiety, have difficulties in their relationships, and often resort to substance misuse, have panic attacks, nightmares. And lots of these adolescents I'm working with who are now, and some young adults in universities, because parents are asking me, will relate their lack of confidence, their lack of ability to have a relationship, their lack of ability to trust people, back to the situation in the family unit, because nobody spotted it. It was a secret. Nobody talked about it. They kept quiet about it. They didn't make their needs known. they didn't understand really some of their feelings. And so it comes back really in ways that are quite damaging to their life and their life chances. Because in every part of life, we have to have relationships as people, as partners, as parents, you know, as professionals in the workplace. And the success of anybody's life is dependent and interdependent on their capacity for relationship. So some of these young people are haunted by an inability to trust other people, and it has serious consequences.
And so when we're, I suppose, looking at it in terms of bringing it back to proceedings, because that's a really clear discussion about, from your point of view, about the long-term damage to these children. Gemma, I know that you're quite keen on making sure that in public places, this is considered not just by the advocates of the local authority and the parents, but in particular the guardian.
Yeah, the guardian and actually the social worker as well. They have a very, very big role to play in assisting and making sure that the right decisions are made for these children who are being alienated. I would say this is especially true if the child is an older child, because what will happen is the older the children get, Sharon, you froze. I don't know if we're recording. What will happen if it's an older child is that people take their wishes and feelings of what they're saying as gospel, when actually what needs to be happening is the guardian and the social worker need to consider these children's wishes and feelings, and whether it's their stated wishes and feelings because they're being manipulated to say these things, or whether or not it's their actual ascertainable wishes and feelings. And that is really, really important. The guardian and the social worker really need to ascertain what a child is saying and what should be happening in their best interests. In order for that to happen, the local authority and the guardian both need to be pushing for fact-finding hearings. They shouldn't be taking sides in terms of parents. They should be actively wanting to make sure that they have the facts correct and that the narrative is correct. And in order to do that, and in order for them to be able to do their job and make sure that they're providing the best possible support to this child and the family as a whole, they need to make sure that the facts are correct. And the only way to do that is to have a fact-finding hearing. So they should be making sure that they are pushing with the parents to have a fact-finding hearing when the matter does get to court. And if a fact-finding hearing is listed, one of the main things is not for the guardian or the social worker to take sides of either parent. It's to go on an either-or basis, because as I said before, whether the child is being alienated or not, whichever the outcome, this child is suffering or at risk of suffering harm. And that is why a fact-finding hearing definitely needs to happen.
And how do we then, as advocates, because of course, you know, we certainly from my point of view, I represent local authorities, parents and guardians. And whoever you're representing, you've got a role to play, and you've got a client whose views and interests you are there to represent. It's a really complex interplay, isn't it, between all of them? How do we balance that?
Again, I think the situation is if you represent a parent who is, to be fair, if you're representing any parent, whatever their narrative is, they would clearly want the court to listen to what they're saying and most likely say that what they're asserting is a fact. And you have to explain to your clients that the only way for that to be determined is by a fact-finding hearing. And if you're a parent who is saying my child is being abused by the other parent in some way, the court has to make a determination on that to make sure that your child is getting the best possible help and support.
Okay.
If you are representing a parent, whichever parent it is, they want their narrative to be the correct one. And you would have to advise your client that in order for that to happen and for the court to agree with that, the facts need to be established. So it's in the interest of either parent to make sure that fact finding takes place so that their story can be put across and then the court can determine what is true. Because no matter what the court determines is true, that child will need some support. And the only way to get it and to know that the correct support is being provided is if the facts are clear. And the fact finding here is the only way to really do that.
Trish, I know that you've had lots of experience outside of this jurisdiction, and you have very clear views in terms of how sometimes our system goes wrong.
Yeah.
Or set up the right way to deal with these sorts of cases. And I just wanted to ask you your views about that. Yeah. Well, I wanted to just weave back this point into what Gemma has said about the importance of social workers, guardians, and other people who might be directly involved in supporting the family, that it's really, really important that local authorities take seriously the need to deliver training in this area right from the top, and that the leadership is at the top of the organisation at director level. Because there are excellent guardians, there are excellent social workers, but they are not all equipped and trained and have the knowledge base to be able to identify some of the factors involved in parental alienation. So I really want to get that on board, and I really want to say there is an urgency in some local authorities for that training. I think that in other jurisdictions, they have grappled with the same problems. So I was in Israel in December 2019 at the International Society of Family Law Conference, and I asked if I could go to the Jerusalem Family Court with a colleague who's a retired judge. And I went there to find out how they address some of the issues that come up in relation to identifying at the earliest stage, at the first point, parents go to court. And what they do in the Jerusalem Family Court is they have somebody with a psychological training, not necessarily a psychologist, and a social worker. So it could be a psychotherapist or a psychologist. And they assess the parents independently before they go into court to see the judge. And they will make a recommendation to the judge, again independently, whether these parents would benefit from systemic co-parenting family therapy, or whether they would be agreeable to do that as a way to try and come to some kind of an agreement, and then go back to court at a later stage, having agreed what needs to happen in the best interests of the children. Where there are not issues of domestic abuse, and if there's issues of domestic abuse, as we all know, that's a very serious matter, and or child protection concerns with one parent or the other. But where there isn't, in Israel, they're not waiting to find out which parent is at fault for the ending of the marriage or the relationship. And contact is ordered straight away so that there isn't a gap in the contact between one parent and another. And so they have stemmed the tide of the length of time that it goes on, because it can go on a long time because we're waiting for hearings, or the courts are really busy, or one parent doesn't, isn't going to want to be involved. Sorry, I've lost my train of thought there. You have to cut that bit. To sort of say something about the importance of looking at other forms of conflict dispute resolution that are actually geared towards, that are child focused, that are geared towards listening to the voice of the child in the context, again, of what Gemma said about ascertainable wishes and feelings. As an expert witness, I often find myself cross-examined by barristers for one parent or the other. And I'm impervious when I go into court, because I say I am not here to represent or determine what each parent is telling me. I am here to represent the best interests of the child. And if I feel that the ascertainable wishes and feelings of the child are different to what the parent are insisting and challenging, that I have found that there's something different, because the influences might not necessarily be direct. So it might not be manipulative in a direct way. It can be because the narrative a father has about the mother, the child picks up on that narrative, they come to fear the mother, or vice versa, it can be mother or father. And so in an unconscious and a conscious way, and in ways that are, I suppose, recognizable through the parent's body language when they're in the presence of the other parent, in ways in which they don't make eye contact, the child is in a very, very difficult position. And I think we can help parents. Parents need help when they're feeling they can't manage their feelings with each other. And it is possible to do that. And it's possible to do that because the one thing that unites them is their children. That will always unite them. And we often forget that in adversarial proceedings. That at the end of the day, when all the court's cases are finished and the parents have left the court and the children are growing up, they're still going to be the same parents of those children. And I think there are ways in which we could humanize some of the services, that we regard them as, you know, people who are going to have a long-term, this is going to have a long-term impact on them, what decisions are made about them and how we can help them to move forward. I also recognize that there are some parents who just will not, without a very, very detailed court order, enter into anything to try and help them move forward for their children. But what I see in the child is damage. And what I see in the child, even though they're getting their A stars, even though they've got all these extracurricular activities, and I meet a lot of them, when I'm doing my wishes and feelings session with them and they do all the bits, and then I say, you know, it must be so hard for you. And they will generally then tell me and break down and say, yes, I don't tell my parents really how I feel because I can't. They're not necessarily alienated, but they might be on their way to being alienated. So there's also a time frame when you have these cases. What do we need to do that's robust? How can we case manage? Who else do we need to be involved? And what other expertise can we bring into this situation to support the child? Because that is protecting the child.
Thank you. Thank you so much to Trish and Sherma for sharing your valuable knowledge and experience about this incredibly challenging issue. Your discussion covered an excellent mix of practical tips and fascinating insights into how they do things differently elsewhere. Thank you also to Sharon for organising and chairing this discussion. Trish and Sherma have very kindly agreed to answer some questions now. Please send in any that you have or can think of to our Q&A box. I see some of you have already, but I'm going to start with one from me to Sherma, please. Sherma, do you say that parental alienation presents as a child protection issue because of the level of emotional harm? And if so, does it follow that, particularly in private law proceedings, should children always be separately represented?
Okay, so for the first part, yeah, definitely a child protection issue, because that child is either suffering or at risk of suffering harm. In the video, you heard Trish talk about just some of the things, short, medium and long-term effects that parental alienation has on children, whether it's anxiety or stomach aches, or as they grow older, having substance misuse issues, issues with being social. There's a range of issues. So it affects a child's life it can affect a child's life forever. So yeah, I do think it's a very big child protection issue. And unfortunately, it doesn't seem to get as much notice as, say, for example, sexual or physical abuse, and it should. In terms of whether or not a child should be separately represented, obviously in public law proceedings, they are. In private law proceedings, I guess there's a couple things to think about. One of the things is, if you are doing that, at what stage in the proceedings are you doing that because of the delay? If you're doing it and the child still hasn't had any contact with the parent, and we're a good, say, year into proceedings, it's concerning because you're going to be spending you're going to have to wait for NIAS or CAFCAS to get legal aid. And that 20 working days or however long is just further time that a child is not seeing a parent. But at the same time, if a fact-finding hearing has taken place and a determination has been made that there's alienation, it would be helpful for there to be a guardian, on the basis that the guardian can actually look at this child's ascertainable wishes and feelings and put them before the court.
Thanks very much. Over to Sian.
Thanks, Gemma. Trish, our last question of you, if I may. You were talking about the limitations of CAMS earlier, and I was just wondering whether their thresholds for treatment and their waiting lists are an issue potentially in identifying parental alienation, perhaps particularly in cases of children which are educationally high achieving.
Yes, that's a very good question. And I think we have to look at the complexity of how CAMS is set up and what the government asks the commissioners to provide in terms of services to local communities. There has also been austerity and cutbacks in CAMS for nearly 10 years now. And we hear a lot in the media about money being allocated for mental health services for children. But what generally happens is it is allocated, but sometimes the commissioners redivert the money to other services because they're in need. I'm only making that point to really explain why in CAMS they can't and are not set up to identify parental alienation. They are set up and they have very strict criteria about who, you know, you're talking, I suppose, about the eligibility criteria for services. And the eligibility criteria for services is quite different. An emotional health and well-being issue is not a mental health problem. It may become a mental health problem. So really the service that it should be diverted into is early help services. But it's not identified early enough within the early helps tier 2 system, which would include working with schools, and lots of CAMS tier 2 workers go into schools and do work. And I think that's where we could really capture the information at an earlier stage to prevent a deterioration in the longer term for children then to be referred to an eating disorder service, for example, because some of the way in which they've lost their confidence or they don't like themselves has been somatized into their body. So but then that will be treated as a mental illness. So I just wanted to make a point between, you know, emotional health and well-being issues and mental health problems and how CAMS are structured and what they can provide. But it is a child protection concern and it does meet the threshold in local authorities, but in private law proceedings, that's not what we're looking at.
Yes. Thank you, Trish. And just to clarify for those who might not be familiar with the term, that early help is really the entry stage at local authority involvement, so pre-child in need, which Sherma was talking about earlier. Thank you, Gemma. I'll hand back over.
Sorry, Tricia, just following on from there, it was really interesting to hear about the experience that you've had from your travels and from your general experience. What would you recommend in your ideal world is done at the outset of proceedings to properly identify these cases, to avoid further polarization of the parents' positions and the significant delay that inevitably happens once you start the whole court proceedings? Is it about training the professionals to identify these cases properly, including judges?
Thank you for that question. I think it's another very good question. I mean, I'm an advocate of training. You can't really have enough training for people because, you know, we all come into this and we don't know what we don't know at the time. And I think that the local safeguarding boards are in a very good position to be able to provide that training, because the local safeguarding boards in each local authority area have people from probation, have social work there, have CAMS there, have head teachers there, have the range of professionals that come into contact with children at the earliest stage. And I think if we could deliver training within the local authority safeguarding boards, and that was a part of the mandatory yearly CPD that everybody had to do, and update them on the basis of the latest case law or research or evidence about the improvements in mental health that have come about as a result of early intervention, I think we could start to stem the tide of this becoming a serious mental health problem later on in young people and adults' lives. I think that, you know, it's very, very difficult because there's so many other priorities in local authorities. So having worked in local authorities in child protection teams and in child in need teams, I know the reality behind the scenes in these systems, which doesn't mean we shouldn't be doing something about it, but I want to win the hearts and minds of guardians and social workers and CAMHS workers to say, we understand your pressures, but we can reduce some of this going forward. It's a spend to save initiative if we put the resources in now at an earlier stage. And prevention has to be better than cure in the long run, I think.
Thank you very much.
Okay.
Thank you. Sharma, I'm going to ask you a question which I had noted down, but also Shelley Glaister-Young has asked in the Q&A box, and it's about fact-finding in private law proceedings. Because cases of parental alienation are often typified by quite low-level allegations of domestic abuse, and ones that don't quite add up, as you were talking about, but coupled with the child presenting as not wanting contact, it's quite often difficult to persuade the court that a fact-finding hearing is required because of the level of the allegations, and equally difficult to get the instruction of an expert approved. So you may find, certainly I've had experience of the court wanting to lean towards directing a CAFCAS report to just try and cut through the difficulties, bearing in mind that that might take sort of 10 to 12 weeks, so is a reasonably significant delay. What are your tips for avoiding that course if you're for the non-resident parent?
Well, the first thing is that you've mentioned how long it can take CAFCAS to finalise a report, 10 to 12 weeks. That's a very, very long time. Whereas if you have an independent expert, a lot of their timescales are significantly reduced. And if a child has already not been seeing a parent for 3 months, and then you've got to wait an additional 10 to 12 weeks before we can have any form of movement, obviously trying to get in an expert that has a reduced timescale is one of the things that could be put forward. Because obviously one of the main things is there shouldn't be delay in trying to deal with issues relating to children. So that in itself is something that should be pushed. If at a FHEDRA, when you're there, if you think that there's going to be an issue in terms of parental alienation or the allegations that are being made, and you need someone like Trish to assist you, it may be that you make your application in readiness for the FHEDRA, because then at least the magistrates have, or the court, whoever you're before, has all the information before them.
Can I just interrupt on this one? Just to say that actually it's really important, if you're the advocate, that you identify that this is possibly a case that's involving parental alienation, and that you know what you're talking about. So when you come to draft your position statement, when you come to make your application and your submissions, you are clear as to what it is that you're asking the judge to do and why, and what you're basing that from. And the case law helps in relation to that. So it really is about understanding what PA is about and how it applies, or possibly applies, to the case that you're dealing with.
One other thing I will say, like Sharon said, there is case law, and you don't want it to get to the stage where no one has done anything. This case has been in proceedings for 2 years, and then finally a judge turns around and says, oh yeah, we should possibly have a fact finding, and by then it may be too late. We don't want to have to wait for that, and that's one of the things that should be highlighted. And there is cases where that has happened, and unfortunately, because it's been too late, the court hasn't been able to do anything.
Thank you, Sharma.
This is a question for Sharma and Trish, but Sharma, perhaps you can answer first. We've had 2 questions in our QA panel about mediation, and given the, and I'm just going to roll them into one, given the how you've identified the significance and seriousness of the harm that the children involved in these cases are actually sustaining, and the issue of urgency and delay, what is the role, if any, of mediation, which is often introduced to head off court proceedings? Does it help or hinder? Sorry, I put it very bluntly. Perhaps we'll start with Sharma.
I think that it depends on the family. I think if you are utilising a mediator, I think you may have to think very carefully about the type of mediator that you're using, and someone who has more than just, say, for example, legal experience. They may have some kind of systemic family therapy background, so they can maybe look at the family as a whole and not just the parents. That's maybe something to think about. I guess some of my concerns about mediation is that the resident parent may use that to delay and say, oh yeah, I'm going to mediation and I'm agreeing and we're doing all of these things, and no contact is happening, nothing's moved forward. And instead they're just acting as if they are agreeing and wanting things to progress. So I think a consideration needs to be given as to what kind of mediator you're using, if you are using a mediator. But at sometimes it may be that you've gone past that stage, and mediation is not going to help. And I say that with a heavy heart, actually, because obviously people would like to not use the court to deal with these kind of proceedings.
Thank you. What do you think, Trish?
Well, I think it's a very interesting question again. When I'm doing my expert witness assessments and I'm kind of formulating as I go along and gathering information and getting a sense of the family and the parents, if a parent is an alienating parent and they have a family narrative and they are blaming the other parent because it's all the other parent's fault, I suppose I would raise the question, how can mediation help if nobody can look at themselves and say, what is my part in this? What am I contributing to this? And what is it I need to look at and ask for help with? The same as if you were to refer that couple to systemic family therapy. There has to be some capacity evidenced in an expert witness report that what you're recommending isn't going to waste more time. So if one parent and the other parent show some reflective capacity to reflect on their parenting and maybe to reflect on the hurt that they've caused each other, because by hurting each other, they're hurting the child, then I think a referral for mediation or systemic family therapy is a good idea. But where it doesn't exist, I think it is going to waste time. And then it ends up either the mediator or the therapist, in my case, is blamed because actually it's left down to the process, as opposed to being steered by the court. And that brings in case management issues because everybody wants to give everybody the best chance. But I think without a structure around it in terms of a time frame about how long we're going to allow it, it can go on, as Sherma quite rightly said, for months and years, by which time it's too late for the children.
Thank you.
Thank you.
Thank you. Trish, this is a question for you, really, I think. In public law proceedings, is it your experience that contact is perhaps dealt with more robustly and more swiftly because of the local authority's duty to promote contact with children in their care? And as a wider question, is there greater success associated with that approach, which seems to be perhaps more in line with what you were talking about experiencing in Israel?
Again, a bit like Sherma has said, some of my experience with local authorities when I have actually found a child protection concern during a process that I've been involved with and referred it to a local authority. Some local authorities are excellent and some local authorities do not see what I see. And so they don't promote the contact, or a local authority will, if it does identify parental alienation, will have a strategy meeting. They'll convene a child protection case conference and they will have all the professionals around the table, including the parents, and they will make a decision. If it's emotional abuse, and psychological abuse, which is what parental alienation is, they will register that child under a child protection plan. Now, under that child protection plan, I do get referred cases from various local authorities where they haven't been successful with the parents to try and promote the contact. I think that's really important that we have that because there's leverage to keep it to a time frame, to check on the outcomes, to check on the actions, to ensure that the parents are working hard with support. We're not expecting them to do this without support because in some cases it's unconscious. And in those cases, I think it's gone to court quicker and it's been resolved quicker. but not in every case in every single local authority, which then loops us back to the whole question that we started with, which was around how do we provide interdisciplinary and multidisciplinary training to professionals to be able to offer the best possible intervention that they can at the earliest stage.
Thank you, Trish. That's really, really interesting.
I just have one final question, and apologies to all of the attendees who've sent in these fascinating questions. I just want to, sorry, it's a bit of a spoiler, we will probably be having another talk to inviting Sherma and Trish to come and discuss what happens next once proceedings have started. So a lot of the questions may be relevant for that talk. But just one final question for Sherma. This is stating the blindingly obvious, I know, but how much more difficult does it make the whole process when you have litigants in person?
It can make it very, I guess, well, I would say if you have private law proceedings, it's difficult anyway if you have a litigant in person on the other side. That's almost hands down, unfortunately. But when it comes to parental alienation, it does make it very difficult. I think as a solicitor, one of the main things I think about is if I'm acting for the non-resident parent is not to make the resident parent feel like I'm on them all the time or blaming them, because that's not helping the situation, and you've got to engage with these people on a regular basis. And I think it's also very difficult because they may feel that you are blaming them for the situation and not actually listening, and trying to do sneaky tactics because you're a lawyer, which is not the case. You're just trying to do what's best for your client and more than anything for the children. So yeah, it's the same as private law proceedings. It's very difficult if you've got a litigant in person on the other side. I think they may not fully understand everything that's happening. The other thing you've also got to factor in is obviously costs, because if you have a litigant in person on the other side, especially if they're the resident parent, the amount of cost that the non-resident parent is having to spend for experts or and legal proceedings can just keep going until the point where they don't have any money anymore to keep doing it, which is really unfortunate. So yeah, it's as difficult as normal private law proceedings, but maybe just a bit more.
Awesome. Thank you very much.
No worries.
Thank you, everybody, for joining us today. As Gemma's already alluded to, the discussions that Sherma and Trish and myself had when we were recording and beforehand were voluminous, and there were so many other areas that we wanted to talk about. So really, in terms of this seminar, we've only got as far as a fact-finding hearing and all of the issues involved there. So there will be a second seminar that deals with what happens thereafter, and we hope that you'll be able to join us for that. So thank you again, everyone, for coming. Can I, just before we wrap up, remind everybody of the next 42 Bedford Row seminar. That's on the 23rd of June. It's on a very different topic. It's financial remedies. It's a pension update. James Sharp is going to be in discussion with Nigel Sloan, who is a pensions expert and chair of International Association of Consulting Actuaries. So thank you very much once again.